Welcome to Complying with the South Carolina Insurance Data Security Act by the South Carolina Department of Insurance. This presentation was originally recorded at the South Carolina Bar Conference Center on September 10th, 2018. Due to technical difficulties with the audio-visual file, we have re-recorded this presentation in webinar format and providing that on our website for your use. Today we are going to cover an overview of the law, some of the regulatory, legal, and compliance issues facing licensees. We'll also cover the reporting requirements, such as what do you do after a cybersecurity event, as well as some of the annual reports due from insurers. And then we'll close out with frequently asked questions. The NAIC originally adopted the Insurance Data Security Model Law that established standards for data security, prompt investigation, as well as notification of cybersecurity events. And in 2018, South Carolina became the first state to adopt the model, and it is codified in Title 38, Chapter 99 of the South Carolina Insurance Laws. It also has staggering effective dates, which we will cover in just a few minutes. Of course, the South Carolina Insurance Data Security Act is based upon the NAIC model. And the point we want to get across is that some of the principles in both the model and South Carolina's Act are going to be familiar to those of you that are already compliant with Graham-Leach-Bliley. And the point we want to get across here is that some of these data security measures are, the rules are not prescriptive. They're going to be principles based, and they're going to be appropriate for the size and complexity of the licensee's business. So the Department of Insurance is not going to tell you what processes or what procedures are going to be appropriate for your business. Your risk assessment is going to drive those decisions. We will try to provide as much guidance as we can. We've already issued 2 bulletins on the subject, and we have at least 2 additional bulletins to come. We have FAQs and presentations and webinars like this to provide additional information. Some of the major elements that are driving this Act's implementation include the risk assessment process, implementation of an information security program, development of those policies that are designed to protect the information systems and non-public information, or NPI, and then the prompt investigation and notification requirements when you have experienced a cybersecurity event. For all things cybersecurity related in South Carolina, we encourage you to visit our website that's posted here on this slide. That's doi.sc.gov/cyber. You'll be able to find answers to many of the questions about our law, find our FAQs, copies of this webinar, as well as some of the reporting forms that are required of companies and individuals. During the upcoming legislative session, the department will pursue correction of a Scrivener's error in section 389970. The error is regarding exemptions, and this correction that we'll make will be consistent with the purpose and intent of the Act and the NAIC model. No other changes are contemplated during the upcoming legislative session, and we'll point out that other states are trying to enact legislation that's going to be substantially similar to the model, and will address concerns about a consistent regulatory approach. Thus far in 2018, we have issued 2 bulletins on the Data Security Act. The first was Bulletin 2018-02, which provided an overview of the Act itself. We've also issued Bulletin number 2018-09, and the topic was Notification Requirements as required under the Act. And later in calendar year 2018, we will also issue bulletins on the exemption requirements and also provide additional guidance on third-party service provider programs. Now we will move to the first main session, an overview of the law, and discuss some of the significant components of the law that are facing licensees. Before we discuss some of the significant components of the law, I just want to point out that we are not providing legal advice today. We realize many elements of this Act may be new to you, so we've tried to provide additional guidance to help direct your focus, but ultimately you will need to sit with your IT staff, legal counsel, and management to determine what's going to be appropriate for your business. As I mentioned earlier, the purpose and intent of the Data Security Act is to establish principles-based standards for data security, and also require prompt notification to the department if you've experienced a cybersecurity event. Note that it does not create nor curtail a private cause of action, which would otherwise exist in the absence of this act. So who does this law apply to? It applies to nearly all of our licensees, from the carriers down to the individual level, with a few immediate exceptions. So if you are an individual or a business entity that is either licensed, authorized to operate, or registered under South Carolina's insurance laws, you are considered a licensee. Now, the definition of licensee does not include foreign purchasing groups, risk retention groups, or assuming insurers or reinsurers. But those are the only immediate exceptions. There are exemptions available, but we'll get to those shortly, because those exemptions do not exempt you from all the requirements of the Act, only certain provisions. Note, at a later effective date, you will have to require that your third-party service providers comply with provisions of the law as well, and we'll also get to more of that in just a little bit. So again, our first key definition is licensee, and that again is a person that is licensed, authorized to operate, or registered under the insurance laws of South Carolina, but it does not include a purchasing group, a risk retention group, or an assuming insurer if one of those groups is chartered, licensed, or domiciled in another state. So again, that could include, from the individual level, producers, adjusters, bail bondsmen, etc., or pretty much any insurance licensee that is doing business in the state of South Carolina. The next key definition is non-public information, or NPI, and that is indeed a key definition because this is what your Information Security Program and the Data Security Act are designed to protect. Non-public information, or NPI, can be broken down basically into three different categories. And the first is going to be your business-related information. Your business-related information, if any unauthorized access or loss of that information would cause a material adverse impact to you, the licensee, or your business, your operations, that is considered non-public information. The other two classifications are a little bit more intuitive when you think non-public information. And that second classification is essentially any combination of elements that could be used to identify consumers, such as a name plus social security number, name plus driver's license number, etc. And the third classification of information is basically a wide array of health-related information concerning a consumer. The next key definition is a cybersecurity event. And this is another very important definition because the investigation and notification requirements under the Act are triggered once you have had a cybersecurity event. And a cybersecurity event is defined as an event resulting in unauthorized access to, disruption, or misuse of an information system or information stored on that information system. So again, the unauthorized access to, disruption, or misuse of your information system or information that's stored there. So that's a very broad definition, but the law is going to establish some safe harbors. It does not include the loss of encrypted non-public information if you did not also lose the encryption key. It also does not include an event where NPI was accessed by an unauthorized person, but that information wasn't used or released and was returned or destroyed. And that's going to be difficult to prove, but it is a safe harbor that is established within the Act if you can prove that information was not used or released and it was returned or destroyed. In addition to those safe harbors, please also note that this act applies to electronic records only. Electronic records and electronic systems only. So a power outage or any other benign cause of disruption is not considered a cybersecurity event unless it results in some type of unauthorized access to NPI. So an information security program, what is that? An information security program basically means the safeguards you have in place to protect NPI. The majority of this new law pertains to the development, implementation, and maintenance of a written information security program. More on that later. But note here, and we'll reiterate shortly, that the language here is substantially similar to requirements under Gramm-Leach-Bliley. So one of the major questions we have received repeatedly thus far is, am I exempt? And if so, what does that mean? What am I exempt from? So Section 389970 sets forth some of the exemptions from the information security program requirements. And you're eligible for an exemption if you are a licensee with fewer than 10 employees. You could also be considered exempt if you are covered under the information security program of another licensee, if you are already subject to the HIPAA requirements, which are similar in many respects to our law, and you submit written certification of compliance with HIPAA, you're eligible for an exemption. And then lastly, the department has allowed for an exemption for those that are already compliant with New York cybersecurity regulation, in addition to a couple other pertinent provisions of South Carolina's Data Security Act, including the prompt investigation and cybersecurity event notification requirements. So note at the bottom, if you cease to qualify for an exemption, the licensee has 180 days to come into compliance with the law. So what does the exemption mean? Because it does not mean you're exempt from everything. Here we've tried to show in a table, what does being exempt mean? You are exempt basically from the requirements of the information security program, that being section 389920, but not all the other provisions. Most notably, you are still required to conduct a prompt investigation after a cybersecurity event, and to also provide notification to the Department of Insurance within 72 hours of the occurrence of a cybersecurity event. If you wish to take advantage of the HIPAA or New York Reg exemptions, you will also need to provide annual certification that you are still compliant with their respective requirements. Note the third bullet point on the right, the annual certification that you are still HIPAA or New York Cyber Reg compliant at the time of your filing. So we will provide more guidance on how to file these certifications at a later date, most likely with our next bulletin on exemptions. If you're wondering why we are allowing an exemption for New York regulation compliance, it's because we've determined that they're basically similar in many respects, as we've tried to show you on this slide. So by now we've covered the definition of licensees, some of the immediate exceptions from that definition, as well as the exemptions that are available to certain licensees. But we also want to point out that this act does not include or apply to licensees that do not have NPI. So that's why the definition of NPI is very important. If you do not have NPI, then the act does not apply to you. Or if you're a licensee that only has the NPI of its parent or its affiliates, it does not apply to you. And if you do not have an information system, as that term is defined by the Act that we previously discussed, basically meaning you don't carry electronic information, the Act does not apply to you. And again, at the bottom there, if you're a risk retention group or a purchasing group or a reinsurer that's chartered, licensed, or domiciled in another state, South Carolina's Act does not apply to you. The point of this slide, if you'd like to pause the presentation and look in through it in more detail, is to show that even if you are exempt from establishing an information security program under South Carolina's law, you still have to protect information under various other federal and state laws. And I should also point out that these laws have been in effect for quite a while, so many of the requirements under the South Carolina's Data Security Act should not be new to you. And again, some of the major components of the law include the risk assessment that we'll dive into in a little more detail shortly, and establishing and monitoring that information security program, that is, putting the safeguards in place to protect your information systems and any information on those systems. It also has risk management, some training requirements, and due diligence requirements when dealing with third-party service providers. And the law also requires a prompt investigation and notification to the department in the event of a cybersecurity event occurrence. And lastly, there are reporting, notification requirements, and the annual filing of a certification if you are a domestic insurer. So what if I don't qualify for an exemption? What does the law require of me as a licensee? And the first thing is that you must conduct a risk assessment and then develop, implement, and maintain an information security program continually thereafter. You will also need to designate someone who is going to be responsible for your information security program. And then you'll put the safeguards in place that are appropriate, again, for the size and complexity of your business. We cannot tell you what's going to be appropriate for the size and complexity of your business. It will be the risk assessment that determines that. Third, you'll need to train your employees and vendors, exercise due diligence when you select those third-party service providers. And you'll also need an incident response plan. You need the incident response plan, notify the department after a cybersecurity event, and you also have to notify the producer of record after a cybersecurity event. And what else does the law require? Management must provide an annual report to the board of directors, if you have a board, regarding the information security program. Domestic insurers, and that's not all licensees, just the domestic insurers, must provide annual certification that they are meeting all information security program requirements. And finally, as you can see on this slide, the board will be responsible for overseeing the development, implementation, and maintenance of the information security program. So board oversight is a must if you have a board. As noted earlier, the Data Security Act does have staggering effective dates, and the Act will go into effect on January 1st, 2019. If you have a cybersecurity event at any point after January 1st, 2019, you must provide notification to the department within 72 hours of an occurrence after discovering the occurrence of a cybersecurity event. You should already be working on your risk assessments, your policies and procedures, training employees, and things of that nature. The information security program itself, if you have not received an exemption, that needs to be in place and is required effective July 1st, 2019. And beginning February 15th, 2020, again this is for domestic insurers, they must file certification of compliance by February 15th, 2020 and annually thereafter. And finally, the last effective date to kick in will be on July 1st, 2020, and that is when you must bring your third-party service provider programs into the fold. They must meet the information security program requirements of the licensee. As we wrap up this section of the presentation, we have included a couple more slides here that you can read through when you have more time if you're interested in seeing some of the other data protection requirements that were in effect prior to South Carolina's Data Security Act. And the point here is that some of the risk assessment, employee training, other notification requirements were already in place under different acts. So a lot of the requirements under South Carolina's Act should not be new to you in many instances.
Dan Morris has just highlighted some of the more significant portions of the Act that requires licensees to implement information security programs that protect the confidentiality, integrity, and availability of confidential data and IT assets. This next segment of the presentation or of this webinar is determining compliance with the South Carolina Insurance Data Security Act. It should be probably entitled Achieving Compliance with the South Carolina Insurance Data Security Act, because our goal this afternoon as a part of this webinar is to provide information to our licensees that will help our licensees achieve and maintain compliance. The Act gives the director or his designee the authority to examine and investigate to determine if a violation of the law has occurred. Investigations will review whether licensees have complied with the basic requirements of law. Do you have an information security program? Have you done the risk assessment? Have you conducted prompt investigations of the law? Penalties for violations will be assessed under Section 38-2-10 of the South Carolina Code of Laws. Examinations are conducted on a periodic basis. They're more full scope, or they can be limited in nature, done every 3 to 5 years, and they'll be performed in accordance with the NAIC guidelines. And the NAIC has developed an IT questionnaire and supplemental guidance to aid review of compliance with the South Carolina Insurance Data Security Act. This next segment of the webinar is focused on helping licensees achieve compliance based on some of the questions the department has received to date about the implementation of the data security law. Specifically, the department was asked what it's looking for to determine compliance. So for the next several minutes, we will review some of the questions regulators may ask when determining whether a licensee has complied with the law. One of the other things that we've been asked is for sample frameworks or to recommend a vendor. The department does not recommend vendors. There are cybersecurity experts out there online, and there's guidance online from various federal agencies and other private agencies or enterprises. NIST, ISO, and other cybersecurity experts have framework examples online that you can review for guidance. The NIST framework has been adopted by about, I think, 30% of U.S. companies, and that number is expected to increase. NIST is the National Institute of Standards and Technology. The framework consists of standards, guidelines, and best practices to manage cybersecurity risk. NIST is also a part of the United States Department of Commerce. Please note, though, that there is no off-the-shelf framework that's going to be perfect for your business. Any template that you find is going to have to be modified and customized based upon your risk assessment to meet the specific needs of your business. So one of the things that you need to do, a compliance tip, and probably one of the most important, some of the most important are on this slide, make sure that you're documenting your compliance efforts, that you're methodical in your approach to compliance, and as Dan has indicated earlier, assign responsibilities for your information security program to people and hold them accountable. Devote the time necessary for you to do an adequate risk assessment. Develop a framework for your information security program with checklists for each significant part of the Act, and develop the security policies, standards, and guidelines based on your company's risk assessment. Train your employees. Make sure you train your employees, and more importantly, train your service providers. So let's assume that someone has alleged that ABC licensee has violated the law. One of the first things the DOI will consider is whether the Act applies to ABC licensee. Does ABC licensee have an information system as that term is defined by the law? Does ABC licensee collect, process, store, or distribute non-public information? If ABC licensee does not have an information system, then the Act probably doesn't apply. The Act applies to electronic information. If ABC licensee has an information system and the answer to one or more of the questions about NPI is true or yes, the Act applies unless ABC licensee qualifies for an exemption under Section 3899-70. So if ABC licensee has an information system that's laptops, computers, etc., and collects non-public information, we will then look to see whether the licensee has an information security program. And so if the answer to that question is yes, ABC licensee does have an information security program, then we're going to look at the management structure for that information security program. We're going to want to know who's accountable for implementation of the information security program and what role the board or senior management plays with the governance of the information security program. The information security program has to be written and management should be involved in the development of it. And there should be a top-down approach to cybersecurity within your organization. We're going to want to look at your risk assessment report, as well as the role of the board and senior management. We'll also want to look to see whether the persons that you have selected to implement your program have the qualifications to do so. Don't promote the file clerk to the position of IT manager unless the file clerk has the requisite expertise in information technology to perform the job. But if there is no information security program at your business, when we get there, we're going to look to find out why. Is the licensee exempt? And so we'll look to see if your organization falls within an exemption to the requirement to establish an information security program under Section 3899-70. Like Gramm-Leach-Bliley, the Act requires the implementation of an information security program that's appropriate for the size and complexity of the licensee. The risk assessment is going to be key to determining what a licensee's information security program should look like. So in determining compliance or whether there's been some type of violation of the law, regulators will review that risk assessment to determine whether the licensee has adequately assessed the company's risk. Current laws call for risk assessments that are not prescriptive. If we were reviewing ABC licensee's risk assessment report, we would probably look to see whether it's documented. Is it updated periodically with changes in systems, data, or business operations? Does it allow for revision of controls in response to threats or other vulnerabilities? And are you carrying it out in accordance with the written policies and procedures that you have in place within your organization? If ABC licensee's risk assessment reveals that it must set up an information security program, the department will look to see if the information security program ABC licensee has come up with is appropriate for the size and complexity of its business. The questions shown on this slide are some of the questions we'll ask as a part of our analysis. The answers to some of these questions should be reflected in ABC licensee's risk assessment report. They should correspond to one another. The risk assessment report is the blueprint for the information security program, so they should be related. This slide shows the basic elements of a risk assessment program. The basic elements of an information security program based upon the company's risk assessment. And so the policies and procedures that you should have in place should address technology, people, and process. This slide illustrates under each one of these areas or those categories are some of the types of policies or issues that should be addressed by your policies. And so as you work to put together IT policies and procedures, don't forget about training your employees and adopting employment policies and procedures that help create a culture of cybersecurity within your organization. Training is very, very important to the cybersecurity or the data protection process. The Act also requires that licensees train personnel. Licensees must develop information security and privacy training awareness programs, and these trainings should be provided regularly to employees. This is not a one and done process, but an ongoing process, or ongoing training is contemplated by the law. All employees should be aware of the security risks associated with their activities, their specific jobs, and the policies and procedures that govern what they do within your organization and the organization's systems, information systems. Employees should also be trained on the risks that are identified in the risk assessments that are conducted periodically. And your employees should know that information security is everyone's responsibility within your organization. And if they have a security role to play in your organization, they need to be trained on their duties and responsibilities. Does a licensee have risk management or risk mitigation policies or procedures in place? Well, risk management and mitigation are important considerations for the information security program. If an allegation that ABC licensee has violated the Act, risk management policies and procedures will be reviewed as a part of the investigation, because it goes to the issue of whether this cybersecurity event or incident could have been prevented. The department will be looking to see what risk management strategies were employed to protect the licensee's IT assets. Licensees must choose the right processes and tools to safeguard the business from potential breaches. A comprehensive risk management and mitigation program helps the licensee stay a step ahead of cyber criminals and enables the licensee to resolve threats before they become major issues. The questions that are presented on this slide are some of the questions that we will be asking as we come in to review the risk management strategy that's been employed by a specific licensee. This slide also focuses on risk management, mitigation policies, and procedures. And risk management is very important because the Ponemon Institute, which is affiliated with IBM, it analyzes the costs of data breaches, and it reports that the biggest data breach cost drivers for a business are employees clicking on links that they're not supposed to, and failure to properly investigate anomalies in their system, and failure to monitor systems for vulnerabilities. That's all risk management. Looking at your system and making sure that you've adopted procedures and measures to mitigate your risk to breach. Each of the questions presented on this slide is another part of a robust risk management process. The questions highlighted are part of our analysis about the appropriateness of your risk management policies and procedures. Effective July 1, 2020, all licensees must have a third-party service provider program in place. Licensees must exercise due diligence in selecting a third-party service provider and require that third-party service providers implement appropriate security measures to protect and secure information systems and the data contained within them. We received a number of questions about what such a program would look like and what constitutes due diligence. The third-party service provider requirement is not a new one. I think HIPAA requires this through their business associate program, and Graham Leach Bliley contemplates and has a third-party or requires oversight of third-party service providers. Some federal agencies have already published guidance on best practices for third-party service provider programs. These sources may provide you some guidance as you develop your own. But your program, from the department's perspective, a basic third-party service provider program should have a policy, procedures for monitoring the activities of the third-party service provider, and a contract that sets forth the terms of the engagement, the security requirements that the third-party service provider is expected to follow, and who's going to be responsible for the cost of a cybersecurity event. Okay, something happened. So what does a licensee need to think about when exercise due diligence when selecting a third-party service provider? This slide attempts to show you that. You need to consider the reputation of the third-party service provider, its access to sensitive information, what your contract is going to say about data security, and if there's a gap between your legal obligations and the vendor's systems, and what happens if there's a cybersecurity event involving the third-party service provider systems. You need to explore options to limit the vendor's access to sensitive data or systems with sensitive data. You need to review the vendor's policies and procedures, internal controls and training manuals or materials to assess whether the vendor is able to effectively protect your data and comply with the laws that govern your company's operation. Consider developing an IT questionnaire that addresses how the vendor complies with applicable laws governing non-public information, personally identifiable information, and protected health information, the vendor's privacy and information security policies and procedures, the results of the vendor's risk assessment and remediation plan. You need to look at past security incidents involving the vendor, including cybersecurity events and post-event analysis and remediation, and also look at privacy or data security related litigation or regulatory enforcement actions that may have been taken against the vendor. These will all be key to let you know how seriously the vendor protects its own data and how likely it is that they have the processes and procedures in place to effectively protect yours. Your information security program should be in writing. The Act requires it. And so here is a list of some of the key information security policies and procedures that we're going to be looking or requesting documentation of. Information security governance, risk management, incident management, vulnerability management, training and awareness. This is the type of documentation that we're going to be looking for as evidence of your information security program. Please pay careful attention to this slide, Compliance Insight. These are the common information security program mistakes that companies make. Not developing or failing to implement policies and procedures, not allocating sufficient staff or resources to their information security processes, not enforcing policies and procedures among their vendors or members of their staff, and failing to effectively manage third-party access to personally identifiable information, non-public information, or protected health information, and failing to adequately train or monitor employees. Those are costly compliance mistakes. So if the South Carolina Department of Insurance is investigating a violation of a law involving ABC licensee, when we come in or go into ABC licensee's business, we're going to be looking for these documents, and we're going to request these documents to determine compliance with the South Carolina Information Security Act. Your privacy policy, risk assessment report, information security policies and procedures that were just shown on the previous slide, certifications of compliance forms, cyber incident logs, your third-party service provider policies and procedures, including agreements with third-party service providers, training materials that you have, and any kind of annual report that you might provide to the board or to members of senior management. Data breaches or cybersecurity events are very, very costly events. And the best way to lower the cost of a cybersecurity incident is to have a cyber incident response plan or an incident response plan. Incident response plans are blueprints that help you manage cybersecurity events in ways that limit damage, increase the confidence of your customers or your investors. They reduce your recovery time and costs related to the cybersecurity event, and these plans more importantly help establish roles and responsibilities of employees. They detail the procedures that you're supposed to follow in the event that you have a cyber incident. The plans need to be easy to follow, updated regularly, and tested at least annually to practice and find weaknesses within your plan. And while the likelihood of a cyber attack or a cyber incident is high, it's not a question of if, but when you may have one. If you have a strong incident response plan, you can easily and quickly mitigate the damage of a cyber incident. This slide shows the stages of incident response, and it's related to the one about the incident response plan. The stages of an incident response are verification, and I added here notice to the director, because once you've verified that there's been unauthorized access to an information system with non-public information, we ask that you use the notification forms that Mr. Morris will tell you about a little bit later on in this webinar to notify the Department of Insurance. Containment and mitigation, investigation and analysis. Notification here means notification of consumers, other credit reporting agencies, etc., and the post-response and review process. Licensees need to keep a record of actions taken responding to an incident, and any evidence related to cyber security event need to be preserved. So if ABC licensee has a cybersecurity incident, a part of our analysis of whether ABC licensing moved quickly enough or promptly enough to mitigate damage is, what they did to verify a cybersecurity incident. Did they identify affected systems or hardware, determine the nature of the data maintained in that system? Did they determine whether the incident exposed or was reasonably likely to expose non-public information? And, did they determine whether non-public information or PII was affected and the data elements that were at risk as a part of the incident? We're also going to look to see what the licensee did to contain and mitigate the cybersecurity event. Did they contain the threat by blocking accounts, restricting internet connectivity? Did they change their information system so that it operated in a manual mode? Did they create alternate accounts? Did they remove the malware and patch the vulnerabilities? Did they delete fake usernames or passwords and install two-factor authentication? These are the kinds of things that the department will be looking at, because there's a direct correlation between how quickly an organization identifies a cyber incident and contains it and the total cost. The mean time, that means the average time to identify a cybersecurity event is generally about 196 days. That's the period of time when damage to your reputation, damage to your customers could occur. And so when faced with an incident, it's immediately important to ensure network logging capabilities are enabled and logs are preserved. You should also consider imaging affected computers for later analysis, which will assist in a forensic analysis and be of potential value to you for law enforcement efforts if you want to go after these bad actors or hackers. Finally, incident handlers should attempt to identify and document what computers were unlawfully accessed, the origins of the attack, whether malware was used and what type of malware was used, and what connections were made within the system, whether data was taken, altered, or destroyed. These are all very, very important, a very, very important part of the incident response process. We're also going to be interested in, how quickly you acted as a licensee. Did you promptly investigate the matter? When did you discover it? What was the nature of it? When did it first occur? Is it still going on? How long did it take you to find it? And what was the method of system intrusion? And was non-public information exfiltrated from your system? Licensees need to be very, very cognizant of the legal implications of a cybersecurity event. Did the cybersecurity event trigger individual, regulatory, or consumer, or even media notifications? You need to review with your attorney notice requirements and plans for communicating with the media, regulators, etc. And you need to come up with a notification plan if consumer notices are going to be necessary. These next several slides basically outline the notification requirements for special groups or the notification requirements that may be required under other laws governing the information that you may hold at your company. This slide shows the notification requirements for reinsurers. That's under section 3899-40E. And it basically indicates that you need to notify affected ceding insurers and the director within 72 hours if you're an assuming reinsurer with no consumer relationship. If you're an assuming insurer with a consumer relationship, you need to notify consumers in accordance with South Carolina's data breach notification law, which is section 39(1-90). If you are a seating insurer with a consumer relationship, you need to also follow 39(1-90), and you also have to provide notice to the producer of record in incidents where there is a cybersecurity incident. As the preceding slide indicated, the notification requirements under the law are based on the requirements of section 39(1-90). And that law basically requires notification if the data was unsecured, that means non-encrypted, the data was acquired by an unauthorized person, illegal use of the information has occurred or is likely to occur, and use of the information creates a material risk of harm to a South Carolina resident. The slide, or the rest of the information on the slide, shows you who you're required to notify, what the threshold is for notice, and what the content of that notice needs to be. This slide basically is included for comparative purposes. It shows you what some of the federal notification requirements are under HIPAA and what the threshold is for sending out consumer notices. Likewise, Gramm-Leach-Bliley does not specify notice requirements, but if a breach occurs, the FTC, which shares responsibility for enforcing the provisions of Gramm-Leach-Bliley, they recommend that an organization take immediate action to secure any information that's been compromised, preserve relevant information, and investigate how the breach occurred, employ the security professionals that are necessary to help them determine or assess the breach as soon as possible, and consider notifying consumers or businesses affected by the breach, credit bureaus, and law enforcement. In 2017, there were 1.9 billion records compromised in the first half of 2017. Baker Hostetler publishes a report on cybersecurity or cyber incident responses I think in the report that they did in 2017, there were about 560 incidents. And what they noted was that people continue to be the problem because of phishing tops the list of why breaches occur. They click on things or emails or links that they're not supposed to, that they shouldn't. And crypto miner attacks are on the rise. This slide shows you the penalties that could be assessed for violations of the cybersecurity law. It does not show you the damage that results from damages to your reputation, to the brand, etc. This only deals with the regulatory cost of non-compliance. Cybersecurity Online, which is like an online blog or publication, they report that about 5 million records are lost or stolen every day. Smaller breaches are sometimes not reported. Undiscovered data breaches can be lurking in the shadows of server stacks, and they can tank your stock prices and damage your company's reputation. In 2017, Ponemon estimated that the average cost of a breach was $3.6 million worldwide. The cost in the United States alone was estimated to be about $7.3 million in 2017. During fiscal year 2018, Ponemon estimated there was $2.2 million for incidents involving 10,000 records or less. And it ranged from that $2.2 million to $6.9 million for companies with more than 50,000 records. And the mega breaches, those with more than a million records, could cost as much as $39.5 million. Ponemon projects that the cost of breaches can be reduced significantly if businesses encrypted data, they use multi-factor authentication, and they train their employees and third-party service providers. I hope this part of the presentation has helped giving you a better idea of the type of documentation that the department requires and why it is so important. And so I'm going to end with the same tips I offered at the beginning of this session. Conduct your risk assessments, develop your policies and procedures, train your employees, be methodical in your approach to compliance, train your service providers, develop security policy standards and guidelines based upon your company's risk assessment. I thank you for your attention, and I'll turn it back over to Mr. Morris, who will address the reporting requirements of the, under the Act, and possibly review some of the questions we received later on in this webinar. Thank you.
Okay, now we're going to cover some of the reporting obligations required under the Act. That includes certain obligations for reporting that are required internally to your board of directors, if you have one, as well as some of the reporting obligations that are required after a cybersecurity event, and some of the annual certifications that are required to be submitted to the department. So the first internal report, if you have a board of directors, you must submit to them an annual report that discusses the overall status of your information security program, touches on information regarding compliance with this Data Security Act, and must also include any other material matters related to the information security program. Now I want to point out the code section here, that's 389920. And remember, if you qualify for an exemption, this subsection 9920 does not apply to you. So if you have an exemption, you do not have to submit this annual report to your board, although of course it would still be advisable to do so. Now regarding reports due to the Department of Insurance, if you are a domestic insurer, and I must emphasize that this is not for all individuals and certain other business entities that are considered licensees. This is for every domestic insurer, and you must submit written certification annually that you are in compliance with the requirements of 389920. Now again, if you are able to find an exemption such as HIPAA or compliance with the New York reg, this may or may not be required. You have to read through the code and find out, or send us a question and we can help you out. Regarding these compliance certification form, we have not yet developed the standardized reporting form, but we will provide additional guidance on this in the near future. And please also note that you must maintain all records supporting this certification for 5 years for examination purposes. So hang on to all the documents you have that support this. Here's a screenshot of our current cybersecurity webpage that can be accessed at doi.sc.gov/cyber. This is what the webpage looks like today. It's got some information on the Act, some of the key staggered implementation dates, copies of the bulletins that we've issued thus far, and you can also find a copy of the event notification form as it exists today. I want you to note on the left side of the page, a little over halfway down, there's a $sign that says online services. Report submissions after an event or even the annual certification compliance may be able to be made through SCDOI's online services right there. You can also access that through our home page, and we'll continue to build out this web page as more guidance is provided, more forms developed, etc. So now we want to move on to one of the important pieces regarding notifications. And here, remember that with or without an exemption, if you find that the Act applies to you at all, meaning you did not get one of those immediate exceptions for being an out-of-state purchasing group, risk retention group, or reinsurer, again, those that are chartered, licensed, domiciled in another state or jurisdiction, the notification requirement referenced here is going to apply to you. So the key to the notification is you must notify us within 72 hours of a determination that a cybersecurity event has occurred. Again, within 72 hours after you determine that a cybersecurity event has occurred, if one of two things. One, if South Carolina is your state of domicile, or if you're a producer or individual, if we're your home state, then this is going to apply to you, and you must tell us within 72 hours. And the other classification here is that if the non-public information of more than 250 South Carolina consumers is involved, in combination with, you've either triggered another governmental or another agency notification requirement, or the event itself, the cybersecurity event, has a reasonable likelihood of materially harming any consumer residing in South Carolina or a material part of your normal operations. So either trigger. Again, if South Carolina is your home state or your domicile, there is no minimum threshold of affected consumers. If you have what constitutes a cybersecurity event, if you think back to that definition we covered earlier, then you have to notify us within 72 hours. If we're not your home state but you're operating in South Carolina, there are some different threshold requirements here, and it begins with the trigger being 250 or more consumers involved and one of these other two buckets of information. So again, as we noted earlier, insurers, you must also notify the producer of record if there's been a cybersecurity event. Okay, so what information is required to be reported after a cybersecurity event? Let's walk through the form. We realize here at the department that you will not be able to assess the damage of a cybersecurity event and report everything that has happened within that 72-hour time frame. So on the form itself, you'll note the red boxes. These indicate, just like any online form, the red boxes indicate required information. So we would like you to fill out as much information within 72 hours as you are able to provide, but the red boxes will indicate the minimum required information. And you'll see as we walk through it that it's probably not as much information as you think, at least right away. The point is that we want you to notify us of an event so we can get in contact with you and work through the process with you. But in section 1, we're just going to start off with some of your basic demographic information, like your NAIC number, individuals, maybe it's your NPN, your newly assigned SBS number. You'll receive those in the near future, and your name, email address, and so on and so forth. Section 2 requires dates for the estimated occurrence of the event, as well as its estimated end, and the date that it was discovered. So if you don't know the estimated occurrence date or the estimated end date, you're still working through the investigative process, you are able to click the unknown check boxes to the right of each of those, and that will satisfy the minimum requirements, so you are able to submit this form within 72 hours. In section 3, we're just looking for what type of event. It could be multiple things, so just check all that apply. We're going to learn more information as you work through your analytics and as we're talking throughout the process afterwards. But if it's a phishing attempt or some other type of unauthorized access, that you can go ahead and check off those boxes, so we at least kind of have an idea immediately of what we're dealing with. Section 4 is going to be a little more difficult, probably, at least from the outset, to complete with real detail. But Section 4 is asking for the information regarding how the NPI, the non-public information, was lost and how you discovered that fact. Again, this section is not required immediately, but you'll need to come back and complete that a little later on. And I'll give you some more information on how you finish filling out an incomplete form a little bit later. Section 5 is on third-party service providers and what their involvement, if any, was in the cybersecurity event. Right here, we just want to know their identity, what their responsibilities were or are, and this is another section that is not required to be completed immediately. But here you'll have the drop-down boxes. Was this our information systems? Was it the third-party service providers? Who are they? What do they do? We're just looking for basic information on who we're dealing with. In section 6, it's very simple. We just want to know what types of information was involved, what kind of information was lost, or wrongly accessed. So it's broken into bigger categories: demographic information, was it health information, financial, and just check off any of the boxes that apply. And we also want to know in this particular section what efforts are being made to remediate the situation. So, Section 7 speaks for itself. If you have any idea, just give us the best guess, or you may click off unknown if you don't know yet. But how many individuals or entities were affected, both nationally and in South Carolina? In Section 8, if you think back to the definition of non-public information, one of those 3 classifications was for business-related information. So this could be considered NPI as part of your cybersecurity event. So we would like more details on any business-related information. In Section 9, have you determined that this event triggered any other state or federal notification requirements? Yes, no, and if so, note that we're going to want a copy of that as well if you've already worked one up, or just let us know that you'll be providing one on a subsequent date. In Section 10, we're looking to see if a police report has been filed and if any other regulatory or government agencies have been notified. If yes, what was the date of the notification? If you've got documentation showing that, go ahead and provide that to us as well. There'll be a section later to attach documentation. And in Section 11, we're looking for the contact information of someone we can get in contact with after we've received this notification. We've received a lot of questions about who this individual needs to be. Is there some minimum requirement? Does it need to be my chief risk officer or chief information security officer, anything like that? And the answer is no. We just need the contact details for any authorized representative that we can contact following receipt. It just needs to be someone on your staff that is familiar with the event and is authorized to act or talk on your behalf about this event. And finally, coming into the end of the form is Section 12. It's the attachments. So I've noted in a few of those sections that we would like copies of certain documentations if it's available, that being like the police report or any other internal review documents. We're looking for your privacy policies, and as well as a statement outlining the steps you're taking to investigate and to notify any affected consumers. And lastly is an attestation that you filled out this form to the best of your knowledge, and then you submit the report. And what happens after you submit the report, you filled in this basic information. Perhaps you don't have all the information available to fill out the entire form, and that's okay. Again, the point is to at least tell us within 72 hours that you've determined there was a cybersecurity event, and then we can contact you and start working with you on a plan going forward. But once you submit the form, the email that you provided in the form, you will receive an email acknowledging receipt of this reporting form, and you'll receive in that email a tracking number. And it's very important that you hang on to this tracking number, and you'll use that to come back in to the same place that you used to fill out this original reporting form, and you'll use that tracking number basically to open your form back up, and you can come back as many times as it takes to keep supplementing the form with additional information as your investigative process continues throughout.
The department has received a number of frequently asked questions about its implementation of the South Carolina Insurance Data Security Act. We have basically included a few of those questions, or a sampling of those questions, in this presentation. Is it the licensee's responsibility to determine what is necessary and appropriate relative to authorized individuals under Section 3899.10 subsection 1? Yes, this is the licensee's responsibility. The licensee is the individual or person that must make the determination that it is necessary and appropriate for individuals to be authorized to have access to non-public information within its systems, its information systems. Under Section 3899.20 subsection A, the Act requires a risk assessment. Can this be a self-assessment done in-house? Will licensees be required to use third-party vendor to conduct the assessment? As to the question about whether licensees are required to use a third-party vendor to conduct the assessment, the answer is no, you're not required to do that. The Act is not prescriptive. There is nothing in the Act that precludes a licensee from conducting a self-assessment or from hiring a third-party vendor to conduct the assessment. However, the assessment must be performed in accordance with the Act, and the information or the requirements from the Act are set forth in this response to this question. Should a licensee send supporting documentation along with the certification of compliance? The licensee must submit the certification of compliance to the department, but the licensee is not required to submit any explanatory or additional materials along with it. The certification of compliance is intended to be a standalone document required by the statute. Now, the department does expect the licensee to maintain documents and records necessary to support the certification, should the department request such information in the future. Under section 3890-70, subsection A1, a licensee with fewer than 10 employees, including independent contractors, are exempt from the data security requirement. Does this provision mean 10 employees in South Carolina or across the country? This means that South Carolina licensees with fewer than 10 employees within the entire company or business are exempt from the requirements of section 3899-20. The employees do not have to be geographically located in South Carolina. Do insurance companies licensed to do business in South Carolina but domiciled in other states need to comply with the Act? Yes. The Act defines a licensee as a person licensed, authorized to operate or registered, or required to be licensed, authorized, or registered pursuant to the insurance laws of the state. But it doesn't include a purchasing group or a risk retention group chartered or licensed in a state other than South Carolina, or a licensee that is acting as an assuming insurer that is domiciled in another state or jurisdiction. This basically says that foreign risk retention groups, foreign purchasing groups, or foreign assuming insurers do not fall within the definition of licensee under the Act. Under the definition, insurance companies domiciled in other states that are doing business in South Carolina but are not acting as a purchasing group or risk retention group are included in the definition of licensee. What information will licensees be required to retain under section 3899-20B4? How long must licensees retain this information? Section 3899-20B4 addresses retention schedules. The Act requires licensees to define a schedule for retention of non-public information and a mechanism for its destruction when that information is no longer needed. A retention schedule is a document listing the business's records, the length of time each document will be retained as an active record by that business, the reason for its retention, and the disposition of those records. This provision does not require a licensee to retain non-public records, but instead ensures that licensees who store non-public information do not retain this information indefinitely. Non-public information that is no longer needed by the licensee should be destroyed in accordance with the licensee's record retention schedule. Independent of the provisions that apply to producers as licensees, are licensed agents/producers considered to be third-party service providers for purposes of a licensee's obligations under this section? Stated another way, do licensed producers have dual obligations as licensees and third-party service providers? Section 3899-70, subsection A2 states that the licensee who is an employee, agent, representative, or designee of a licensee is exempt from and need not develop its own cybersecurity program to the extent that the employee, agent, or representative or designee is covered by the cybersecurity program of another licensee. This exemption requires the employees, producers, representatives, or designees' operations to be fully covered by the program of another licensee. Therefore, a licensee who is an employee, agent, representative, or designee of more than one other licensee will only qualify for a section 3899-70A2 exemption where the cybersecurity program of at least one of its parent or other sponsoring licensees' information security program fully covers all aspects of the employees, agents, representatives, or designees' business operations. Under the Act, the obligations regarding third-party service providers are not imposed on the third-party service providers, but instead are imposed on the licensee contracting with the third-party service provider to ensure that the third-party service provider has certain measures in place to protect non-public information and to require that the licensee monitors and evaluates its own cybersecurity program, taking into account any arrangements with third-party service providers. How will the information that is shared with other entities, states, regulatory agencies, and the NAIC under Section 3899-60C1 be secured, protected against potential cybersecurity breaches? The South Carolina Department of Insurance is required by law to have an information security program in place to protect confidential information filed by South Carolina consumers or South Carolina stakeholders. Any questions not answered by this presentation may be submitted to the department at datasecurity@doi.sc.gov. Thank you very much for your attention.